Shield live report in Houston, Texas. I'm Sam Malone at the news desk. Tragedy struck at the campus of the University of Texas. A man with a knife went on a stabbing spree. One dead, many injured. What could have been done? What can be done? Let's get some advice legally when it comes to a U.S. Law Shield. Let's go to program attorney Gordon Cooper in Texas. Gordon, welcome aboard. Thanks for joining us on Skype.
Thank you. Thank you for having me.
Tragic. By the way, you're not a UT grad, are you?
No, I'm from the University of Houston Law Center.
Well, I can imagine Longhorns are very upset about what happened. A man comes out and just starts stabbing people in the middle of the day while they're at food trucks. Let's walk through. We'll get to campus carry in a second. Something like that goes down. License and gun holders, those who have their concealed handgun license to carry, are about to get involved. What are some of the things that should go through your mind that you learn as part of the family with Texas Law Shield?
Sure. So the first thing to understand is that you are legally allowed to defend yourself in that kind of a situation. Under Texas law, anytime you have a reasonable belief you're in immediate danger of death or serious bodily injury, you're justified in using deadly force to defend yourself. And I think it's safe to say that if you see a man going around stabbing people, that you have a pretty reasonable belief that you are in danger of death or serious bodily injury. And likewise, Texas law also allows you to defend other people as well. So if the situation is one as you reasonably believe it to be, such that if you were in that person's shoes, you could defend yourself, you're allowed to defend that person on their behalf. So if you see someone get stabbed at the food truck, you have the ability to use deadly force against the stabber, even if the stabber is not directly coming for you, but to defend another person.
All right, so you're going to do a great thing. You are licensed to carry. You've passed all the tests, the background checks, fingerprints, the shooting test, the Q&A. You're on campus, and you see this madman stabbing people. You draw it down. You're ready to rock and roll. But he's moving. There are many people. What were to happen? What does happen legally when you are going to do a good thing, but you miss, and an innocent bystander is then struck by your bullet from your gun?
Sure. So here in Texas, there are some times where even if you make a mistake, unfortunately, we live in a world where there's no such thing as perfection. Even the most sure shot can go astray, on a bad day. So Texas law does give you some self-defense coverage, even if you accidentally hit a third party. The key differential there is that if it happens in negligence, then that's one thing. However, you do lose your self-defense protection if you are shooting recklessly. So what does that mean? That means you knew you were engaging in a dangerous activity. You engaged in that dangerous activity, and then you did so without justification. And that third point is the key point here, because we all agree, one of the first rules of shooting safety, know your foreground, know your background. So your background has people in it. We would all agree that it's dangerous to shoot at someone if there's a background of innocent people, right? We know that's dangerous. But let's say you take the shot anyway. Do you have a justification for doing so? Yes, right? Defense of yourself or defense of another person. An example of recklessness would be, oh my God, this stabbing guy is terrifying looking. I'm going to cover my eyes and take the shot, right? We all agree that covering your eyes and shooting is dangerous, hopefully. If you don't, you need to call me and we need to talk some things out because you're in big trouble. So we agree that's dangerous. You do it. But you don't have a justification for covering your eyes, right? There's no legal justification for he's scary to look at. So that would be an example of a reckless activity. A mistake, missing, or even over-penetration or things like that, and a third party gets injured, you should still be able to use, I was defending myself. It's unfortunate if it happens. You don't want that to happen. But you can still have that defense available. But whatever you do, don't act recklessly.
Great. Gordon Cooper, independent program attorney with U.S. Law Shield. But there's still a liability side to that story. Should you, and you're not reckless, your eyes aren't closed, you don't have your hand over your eyes, unfortunately a bullet goes in a different direction, is there a liability side, a civil side when it comes to it? You're not going to jail, but you could be sued.
So that's a great thing to point out. You can be sued by anyone, anywhere, for anything at any time, right? The key point is, are you going to lose? Are you going to have to pay all your money, empty out your life savings or whatever to pay off this lawsuit? Texas does provide some protection. It's not fantastic, but it's something. It's called a civil liability immunity statute. And what it says is if you are justified in your use of deadly force, you are immune from all civil liability for claims of personal injury or death. Now, there's some key words there because what people hear when I say those words is I'm immune from lawsuits, I'm untouchable. But civil liability immunity means the money you pay out if you lose. And as stupid as it sounds, you can be sued even though technically the other party shouldn't get any money out of you. Because unfortunately, at the end of the day, there's no one at the courthouse that says, all right, good lawsuit, oh, bad lawsuit, throw it out, good lawsuit. No, right? You have to actually show up to court to do that. If there was someone at the courthouse that threw out bad lawsuits, I wouldn't have a job, right? Life would be ideal.
Exactly.
But,
yeah. Oh, that's amazing. Program attorney Gordon Cooper with us. By the way, we broadcast live on Facebook. That's where you're watching right now, Facebook Live. And you can leave your comments and or questions on the screen, and I can read them to Gordon. In fact, Mark just posted, he said, I thought it was a shooting. I didn't realize it was a stabbing, so the same law applies regardless if the perpetrator has a gun or not? That's a great question. And thanks, Mark, for the comment on Facebook Live here at Texas Law Shield. So does it matter, Gordon, you're the program attorney, whether the bad guy has a gun or whether the bad guy has a knife or he has a baseball bat or something else?
That's a great question. So deadly force is defined as force that by its use or by its intended use causes or is capable of causing death or serious bodily injury. Serious bodily injury means broken bones, maiming, scarring, things like that. So the important three takeaways from that. Anything that does cause death or serious bodily injury is deadly force. So seeing someone get stabbed and they die right in front of you, that's deadly force, right, one way or another. Also intention. So let's say he didn't have a knife, but he had a baseball bat. If he's swinging that baseball bat at people's heads, even though a baseball bat can sometimes be sporting equipment, in that instance, it's a deadly weapon because he is intending to kill people with it. And likewise, anything that could cause death or serious bodily injury is deadly force. So if prime Mike Tyson punches a 90-year-old, 70-pound woman in the face, right, that could very seriously hurt her or potentially kill her, right? So in that instance, his fist can become the deadly weapon. So just because it's not a gun doesn't mean you just got to sit back and say, oh, nothing I can do, and then just get stabbed or whatever. You can defend yourself just as well against a gun or a knife or anything else if you're afraid for your life.
I always thought that was like a 1970s sitcom joke. My hands are registered with the FBI as lethal weapons. But that's so you can also look at the person involved in the assault. Like you said, if it is a trained boxer or something like that who's got a heck of a punch, Mike Tyson's hands might be. I'm not a lawyer. You're the lawyer, but might be considered deadly weapons.
Exactly. It's very fact specific, of course, but if it is capable of causing, if it could cause death or serious bodily injury, then it is considered deadly force under Texas law. All
right, we'll continue. Let me ask you this. Gordon Cooper, our program attorney with U.S. independent program attorney with U.S. Law Shield. Does location matter? I mean, this is a heavily crowded area versus an open field, right? Should more thoughts go through your brain about, gee, this is a really crowded target area versus being out in the open? Should that come into play if you're going to come and try to save the day?
I definitely think it should. Number one, because ultimately, I know this is going to be weird to hear some kind of moral advice coming from a lawyer, because generally, we try to avoid morals or ethics altogether.
Nice.
But,
nice.
People do feel bad about hitting innocent parties with stray fire if you're trying to stop the bad guy. And at the end of the day, even if you stop the bad guy, if you killed someone who didn't deserve it, you are going to feel bad, just generally. But especially in this circumstance with a knife, some people know of this, some people don't, but there's this thing called the 21-foot rule, as it's popularly referred to. And you can go on the internet and find videos of it being demonstrated, but it's the general concept, because nowadays it actually goes beyond 21 feet. But it's the general concept that within that distance, someone with a knife can run up and, stab you and potentially kill you before you have the chance as a gun owner to draw your gun and shoot. So if you're in a very crowded area where space is tight and constricted, and someone has a knife and they're looking in your general direction, even if they're not directly on top of you stabbing you, I think you still have a very reasonable fear that you're in danger of immediate death or serious bodily injury. So I think that plays into it a lot.
Gordon Cooper, independent program attorney with U.S. Law Shield. I'm Sam Malone. We're on Facebook Live. If you have your questions or comments, you can type them in as we're doing our program. And real quick, put up on the screen, this is from the University of Texas. They actually have campus carry. that was passed through the state legislature. And it says, Campus Carry Priority says, the University of Texas at Austin is committed to providing a safe environment for students, employees, university affiliates, and visitors, and to respecting the rights of individuals who are licensed to carry a gun as permitted by Texas state law. And it goes on to give the eligibility who can carry. And it says, for instance, individuals who hold a license to carry are eligible to carry a concealed weapon, a handgun on campus. License holders must be 21 or older, must clear eligibility requirements related to criminal background, mental health, so forth and so on. So this is saying, yes, if you have a concealed, CHL, license to carry, you're good to go. But what if you don't, Gordon, and you see a madman going on a stabbing spree? And you say, I'm going to jump in, but you're not licensed to carry. You don't have your CHL.
Sure. So anyone can have a concealed firearm in the vehicle, even if you don't have a license to carry in Texas. So let's say, you just parked your car, you're walking from your car, and you see someone get stabbed in the food truck in the parking lot. You can run back and grab your gun and, defend yourself or others from this knife-wielding person and use what's called the defense of necessity against the crime of unlawful carry, right? Because technically, even if you're carrying this gun around and you don't have a license, you're committing the crime of unlawful carry. However, what the defense of necessity says is, yes, I committed a crime, but it was to prevent something worse from happening, right? So, for example, if a school bus driver is blazing down the street and then some little kid wanders in the middle of the road, so he swerves and he runs over an azalea bush. Generally speaking, azalea bushes shouldn't be destroyed for no reason, right? But it was not as bad as running over that little kid. And so we will forgive the destruction of the property, destruction of the azalea bush, because the harm he committed was outweighed by the harm he prevented. And so likewise, even though you ran back to your car, got your gun, and was carrying it in a place where you otherwise couldn't, you were preventing something worse from happening. Now, a key distinction there is you have to actually be preventing or attempting to prevent some kind of harm. So if you say, you know what, today's Friday the 13th, I got a bad feeling about today, I'm going to carry even though I don't have a license, at that point you're carrying without actually trying to prevent some kind of harm, and you could potentially be on the hook for an unlawful carry charge, which is a Class A misdemeanor, up to a $4,000 fine, and up to a year in jail. So you kind of have to weigh out, am I willing to risk the Class A misdemeanor because of this bad feeling?
Interesting. All right, we've learned another thing. So say it again, it's this law of...
the defense of necessity.
Defense of necessity, and then we have the 21-foot rule. So the defense of necessity is, all right, I'll take the lesser problem of a Class A misdemeanor, but I did it to help others, to serve others, right, to save lives.
Correct. And the law will forgive the Class A misdemeanor.
I did not know.
Because what you did it was better.
I did not know that. And then the 21-foot rule, let's go through that one more time before we wrap it up.
Yeah, and the 21-foot rule is more of a concept. You're not going to find that in a statute. But self-defense experts everywhere will testify on this on your behalf in court. But the 21-foot rule is the concept that within that distance, a knife wielder can come up and actually stab you before you as a gun owner have a chance to draw your gun and pull the trigger. And you can find videos of it all over the internet. And
because we're on Facebook Live and there's so many comments flying in here, what about a long gun? You have campus carry, which is concealed. What if I love my AR-15, made by Colt. It's got my initials on it and everything. I want to take that to school. Can I walk on campus with an AR-15, which is totally open, totally exposed, totally visible? Is that allowed, Mr. Gordon?
So the aspects of 46035, which is the prohibition on carrying a handgun by a license holder, it doesn't apply to long guns, right? So long guns are kind of their own separate animal under Texas law. But what you have to keep in mind there, especially at UT, because they've had tragedies in the past involving long guns and all that, they're going to be at a heightened sense of security, and they're going to ask you to leave probably immediately. And they are allowed to ask you to leave. And if you don't do so, you're a criminal trespasser, and that's that Class A misdemeanor again, $4,000 fine up to a year in jail. So theoretically, you could try it, but I would bet you dollars to donuts that you're going to get asked to leave immediately. And on top of that, unfortunately, Texas kind of has this vague law called disorderly conduct, where you can't carry a firearm in a manner calculated to alarm. And what a lot of cops will do is they will say, well, didn't you know someone could get afraid because they saw you carrying a gun? Well, that sounds like calculated to alarm to me and arrest you.
Oh, man. Wow.
Yeah. One of the other attorneys in the office, Edwin Walker, is currently fighting an issue like this in the appellate court level, trying to get that law declared as unconstitutionally vague. We're still fighting that. It's still ongoing. It'll probably be a long time before it gets resolved. But it's important to know kind of what you're up against if you do decide to do something like that. So my advice, if you don't want to get arrested and potentially be Edwin's next test case, I would leave it in the vehicle or, even leave it at home.
One more comment on Facebook before we wrap it up with Gordon Cooper. How important is it to make your intentions known to the perpetrator? There's a bad guy and he's on campus and he's stabbing people. How important is it for me to yell out loud, "Hey, stop, I've got a gun," or something like that, versus not saying anything and walking up? Does it really matter? Does it play? I just saw you go, ooh.
Well, anytime you're in a crowded public place and you scream, "I've got a gun,"
yeah, it's true.
I think you were definitely stepping into dangerous territory, because if there's a cop somewhere and he just hears "I've got a gun" and he doesn't see the guy with a knife, you may end up in a very bad situation. So it's definitely very careful. And I don't want to come across as being Gordon shoot first, ask questions later Cooper, right? I'm not Charles Bronson or anything. Generally speaking, for any kind of active attacker or active shooter situation, law enforcement recommends, and I agree 100%, with the strategy of run, hide, fight, in that order. So if you see this happening, trying to get away is probably most people's best options. Hiding is another great option. And then if you can't do those, or morally you just refuse, you can fight, right? And even then, you just have to be very, very careful, because imagine, if you will, he stabs someone at the food truck, you shoot the bad guy, right? You're the hero of the day. You stopped this before it got out of hand. Someone turns the corner. They see a guy with a gun standing over a dead guy. They have no clue what's going on. So then they shoot you because they think you're the next school shooter, right? It could happen. And so it's a very, very difficult situation to be in. So I personally, you kind of have to gauge the situation as best as you can, right? There's no bright line answer. There's no easy answer to that. But I think saying, "Stop, get on the ground now," verbal commands are a better idea than saying, "I've got a gun, I'm going to shoot," things like that. I think saying, "Get down on the ground now, put your hands where I can see them," in your commanding voice, your big boy voice, is going to do much, much better than saying, "I've got a gun."
Got it. Good job today. I appreciate you taking the time to join us. Gordon Cooper, program attorney, independent program attorney with U.S. Law Shield. Any questions? Of course, you can watch this video. We're on Facebook Live right now, but as soon as we're done, it'll start over. Watch it, learn. Any more questions, go to uslawshield.com. Gordon, thanks for taking the time to join us.
Yeah, thanks for having me, as always.
Got it. For U.S. Law Shield News Update, I'm Sam Malone in Houston.